276.
Right, we are on record today for a review that has been consolidated with a request to terminate the parental rights of both parents. May I have the names of our participants, please?
Lee Heiss, lawyer, guardian ad litem.
Sasha Thomas, counsel for the department.
Kristen Smith, foster care worker, Catholic Charities.
Michael McFarland, representing mother. I've been advised she's been served. I did not see her out in the hall. I don't know if she's on Zoom.
I don't believe so. Some representatives from the department. Mr. Brooks, would you like to go ahead with your appearance?
Michael Brooks, I represent the father, Mr. Zavala Garcia.
Yes, we did. We got a notice from the prison where he's at in California that they were having trouble connecting to the Zoom. For purposes of proof of service, I have a proof filed May 7th indicating that Enrique Galvin, a litigation coordinator, was able to personally serve your client, Mr. Brooks, at the prison with a copy of the summons and the petition. And your client, Mr. McFarland, was served also. You got a proof of service on that one from, here it is. Ms. Kristen Smith, our foster care caseworker, indicates on May 8th at 10:30 in the morning, she served your client at Victory Clinical Services. There's no box checked for personal service or certified mail. Maybe we can take some testimony and then it does look like there's a date and time. So Ms. Thomas, do you want to further address?
Okay. Yes, Chair, I can have Ms. Smith just give brief testimony on the type of service that she completed.
All right, Ms. Smith, come on up to our witness stand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you. Come on up, have a seat. Ms. Thomas, whenever you're ready.
Thank you. Ms. Smith, as it relates to Caitlin Smith, this is me confusing. So I'm going to just refer to you as Kristen and then we have not Caitlin, okay? There's the proof of service that was that accompanies the summons for this case. And there are two options: to personally serve or to serve by registered certified mail. You have signed this proof of service and it is notarized. Can you confirm whether it was through personal service that you handed Caitlin the petition and summons, or did you mail it?
No, I personally served her at Victory Clinic that day.
Okay, thank you for that. And can you just reiterate what you provided to her?
The termination petition and the notice.
Okay, the summons. Okay, thank you. With that, Judge, I have no further questions as it relates to service. Thank you.
Any questions? Well, yes. Has my client been in contact with you since that date of service?
No.
Thank you. Nothing further, Your Honor.
Mr. Brooks, any questions on the issue of service?
No, Your Honor.
All right. I'm going to let you sit right there for a minute, Ms. Smith, because I have a feeling you're going to probably be one of our witnesses today. Any comments before we commence proceedings, Ms. Thomas?
No, Your Honor.
Mr. McFarland?
Your Honor, I would move that I could be excused from this review and trial as my client's not here. I have no idea what Mom's position would be, so I cannot really be effective as counsel.
Any objections?
No. No, Your Honor.
I have no objection.
Right, I agree, Mr. McFarland. I think the lack of communication and the failure of your client to appear renders you unable to adequately advocate for your client. You have made sure that she was properly served, and I feel you've satisfied your obligations in that sense. You may be excused.
I will be in the jury room reviewing files if she does here.
Appreciate that. All right, Mr. Brooks, I know we're waiting for your client to join us by Zoom, and I'll be happy to give you a chance to talk with him if you need to when he joins us.
I really don't, Your Honor. My client's been in prison for several years and nothing has changed.
Very well. Well, I would appreciate it if you could stay on for a bit. Hopefully they'll be able to join us from California and we'll get his preference as to whether or not he wants to continue to participate or not.
All right.
Very good. Any comments before we begin?
It would appear that my client was appropriately served with process.
All right, Ms. Heiss, did you want to make any comments now or reserve?
Your Honor, I just want to report now that I did see the child in person, and I will reserve my comments on best interest of the child for closing.
Ms. Thomas?
Thank you, Your Honor. I'll start with Ms. Smith, as she is our only party present today. Okay. Ms. Smith, Kristen, sorry. You have been the ongoing prosecutor worker for some time on this case, is that accurate?
Yes,
Okay. And you drafted the petition that's before the court today,
yes,
and you've also provided us with an updated court report.
correct.
As it relates to the court report, are there any updates or modifications that you're aware of that need to be made to it?
No,
And just to confirm, there's your court report, the letter sent to Mr. Zavala Garcia's relatives for engagement, the email to the litigation coordinator at the prison in which Mr. Zavala is located, and then the forensic fluids report of Ms. Caitlin Smith. Is that correct?
correct.
Okay. And gonna kind of combine this, so that question might be awkward, but as it relates to mom only, when is the last time that you were able to see mom's home?
Could I look at the petition? I don't have it in front of me for the exact date. I'm trying to think. The last time I saw her home would have
Well,
been
did you-
maybe,
Did you see her home in the last review period?
No.
Okay. And prior to, during our last review hearing, you noted that you received an email from it reported that it was from an estate's personal representative, that mom was renting a house from an estate.
yes,
But were you able to ever confirm that, like by talking to this individual on the phone?
No.
Or,
the number that she provided me with was not in service.
and was there any change to that during this review period?
Not to my knowledge.
During this review period, did Caitlin Smith provide you with any proof of employment?
No.
And the last that you knew was that she was fired from her employment back in December, but failed to report that to you?
Correct. I attempted to verify her employment and they had said that she was let go due to attendance issues back in early December. I believe it was like the first week in December that she was let go.
Okay.
She never reported that to me or if she had obtained new employment.
And to the best of your knowledge, or during this review period, has Caitlin provided you with a copy of a valid driver's license, proof of insurance, or anything like that?
No.
And as it relates to substance abuse, the report indicates that she has not shown for any of her drug screens. Is that still accurate?
Through forensic fluids, yes. Her engagement with Victory Clinic is very limited or unknown. The day that I served her, May 8th, I had asked to speak to one of the supervisors there about a release on file. She informed me that there was one, but it was very limited. The only thing that was checked was attendance. So she was able to verify that Caitlin was still coming to Victory Clinic. But that was it. She couldn't tell me any drug screens or sobriety or anything like that. All she could confirm was that she was still coming to Victory.
Okay. And to the best of your knowledge, as of May 8th, I guess, Victory Clinic, what would the purpose of her attending that clinic be?
It's a methadone maintenance clinic.
How long has she been on methadone maintenance, if you know?
at least since I've had the case. I was assigned the case in February of 20.
Did, during this review period or even prior, did Ms. Caitlin Smith ever provide any documentation of attendance in weekly NA or AA meetings?
Not during this reporting period, no. I believe the last was October.
And those that she did provide, were they from like the facilitator or the facilitating agency or from her?
From her. The recent ones were like handwritten. She would just make a note of, the online one that she had attended, but there wasn't a way to verify those.
And to the best of your knowledge, she was still screening negative for all substances during that period of time?
What period of time?
When she was providing you the handwritten notes from
Yes.
NA.
All right, there you go.
Okay, hang on 1 second. Good afternoon.
Good, could you hear us and see us?
Yes, we can. May I have your names, please, or whoever's going to be participating?
It's Mr. Say your name is?
My name is Ruben Zavala Garcia.
Thank you. Well, okay, Mr. Garcia, today's the date and time for a review, permanency planning hearing, as well as the request for termination of your parental rights. Your attorney, Mr. Brooks, is here present with us as well. We have begun testimony, but because you weren't with us yet, we've begun testimony as it relates to the mother of the child first.
Okay.
You are welcome to continue to stay. If you would prefer to leave, you're not obligated to stay for the hearing. I also have your attorney here. If you'd like to chat with him, I can set you over the breakout room. What is your preference?
I would like to stay and have a few words with the attorney as well.
Very good. All right, I'm going to set you up in the breakout room so you can accomplish that while we talk about mom's case.
Thank you.
Okay, Mr. Brooks, if you could verify that you've heard us.
I heard you.
Very good. All right, you should have that invitation for a breakout room now. Thank you. You may continue.
Thank you. Did you have any reason to doubt Caitlin's sobriety during this case?
Yes.
Can you just detail that a little more?
So initially, there's always a question of the release and the specifics that she checked marked essentially to give us information from Victory Clinic. I was never able to get the screens directly from Victory Clinic. Caitlin would always have them printed and then she would give them to me. I never wanted to duplicate services, so I didn't want to make her screening, I didn't want to make her go screen multiple times. As long as we could exchange the information, it was less work for her to do. So I had decreased her requirement to screen through forensic fluids as long as she was screening through Victory and she was able to exchange those screens. And that went on for a couple months. And she would give me the, screens and they were all clean and they were submitted to the court. And then when I contacted Victory Clinic to get them directly, they had informed me that Caitlin should never have been doing that because they can be easily altered. Essentially, they said you could just, the categories of the drugs that are listed, it only has an X. So she said essentially you could just use whiteout, cover up the X, make a copy, and it looks like a clean screen. So I don't have evidence that she did that. I was just informed by Victory Clinic that the screen should have always came directly from Victory, never from the client. So at that point is when I kind of pressed Caitlin and made sure that the necessary releases were signed and to specify what I could or couldn't get. And that's kind of when she stopped screening altogether. She didn't go to forensic fluids. So we don't have positive screens from Caitlin, but there is absolutely a question of whether or not she was sober or altering the screens.
And as it relates to her mental health, She did participate in a psychological evaluation, correct?
Correct.
And did she complete all of the recommendations?
No.
And part of that was demonstrating sobriety through negative drug screens, and that there's a question about that. Attending outpatient substance abuse treatment programs, as part of Victory Clinic, was she attending any outpatient services?
Not in addition to Victory Clinic. I know that she went there daily for her dose and that she met with her therapist individually once a week.
And she also has mental health diagnosis for ADHD, is that correct?
Correct.
Was the medication that she was taking from that, were they amphetamine based, do you know?
No.
Okay. And so the provider was aware of her prior substance abuse history?
Yes.
Do you have any indication that she was maintaining any psychiatric medication regimen according to how it was prescribed, or was she not maintaining that?
No, she was not taking medication as directed or attending appointments. She actually never met with her psychiatrist in person. They were only like telehealth or Zoom. She missed several. And then the medication that she was recommended or prescribed, she didn't want to take.
And I know that this was part of a prior hearing, but what was the issue from her perspective about taking the recommended medication?
So originally they prescribed her with Strattera, and then she didn't like, I believe it was side effects. So she had asked for something different when her psychiatrist prescribed her something different. And I can't recall the name of the medication, but it's normally used to treat bipolar disorder. When Caitlin saw that, she argued it. They tried to explain, that essentially it would also help her with ADHD. They weren't necessarily diagnosing her with bipolar. They said that, they couldn't at that time, but it was just a different medication that could help manage the same symptoms. She didn't want to take it. I don't believe she ever picked up the prescription. She refused. At that time, she had several back-to-back appointments with her primary care doctor. And she was requesting, I believe it was noted, she wanted something similar to Adderall, not Adderall, but she wanted something similar. And she did sign a release for her primary care doctor. And during those appointments, the primary care doctor, expressed to her that they can't trump what her psychiatrist has already prescribed her with, and they weren't going to change her medication, that she needed to follow up and work that out. And I think she came back a second time, and then they said that they would give her one refill at this point, but that was going to be it. And at that point, Caitlin had said that she really doesn't need the medication. She's probably not going to take it. She just needs it to look like she was taking it for this court case.
As relates to the child's best interest, during the duration of this case, at some point, mom was demonstrating some stability. Is that fair to say?
Yeah.
And she was moving on to unsupervised parenting time?
Yes, we were progressing to that. I believe she had maybe 2. At that point, the housing kind of fell through. So then there wasn't an appropriate place for her to have the supervised visit or the unsupervised parenting.
When did you notice the change in her interactions with you and with her case service plan?
A slight change, I would say probably around November. She had moved homes, she broke up with her boyfriend, so she did have some barriers that weren't expected. I was really trying to work with her, and at that point, I just, kept stressing to her that she would we gotta get the ball rolling. We've been in limbo for a while. So she was pretty resistant, she gave me a lot of pushback then. And then it was the FTM that we had in February. That was when we kind of, we all said we're going to be asking for a goal change. These are the same issues that haven't been dealt with. So in February is really when we definitely saw a different Caitlin.
One of the, so some of the reasons the child came into care were the substance abuse, neglect, lack of participation in CPS, inability to meet the child's basic needs, and also her involvement with perhaps an overdose death that she might be part of. And at that time, the child also had significant needs. Is that accurate?
Yes.
Okay. One of the allegations, or one of the grounds for termination that we've alleged, is that mom hasn't made sufficient progress to rectify those conditions that brought the child into care. And some of those other conditions were homelessness, unemployment, lack of income. Has she demonstrated any ability to meet the child's basic needs at this point in time?
No.
Has she demonstrated any stability for this child?
No.
As relates to parenting time, when is the last time that she saw this child?
February 24th.
Has she contacted you since February 24th to see him?
No.
Part of the issue that I think we discussed at the last hearing was that she couldn't come to Adrian, I think, for parenting time. Or can you just refresh my memory as it relates to that?
No, it wasn't that. So before we went, so visits were always at, not, I'll say always at Adrian, but when they were supervised by the agency, they did take place at our Adrian office, because the child would get dropped off from the school bus and then she would come here. The argument was she didn't feel that her visit should be supervised, so she refused to come.
And when, after our hearing, and it was going to continue to be supervised, or the court actually asked even for maybe a therapist recommendation on that, did she reach out to you at all to see an update on that?
No.
At this point, it's been it's been 4 months since the child saw mom. So this question's harder, but how would you describe his bond with her?
I don't think that there is much of one left. Because of he is autistic, and he really relies on his calendar, his planner. He knew the day of the week that he visited with mom. He knew Wednesdays. It took a very long time for him to get off that topic. And then when they went to, weekends, there wasn't consistency there either. And then when we came back to court at the last review, we were gonna go back to essentially the Wednesdays, and I had informed, the caregivers, don't tell him about Wednesdays again. Let's just, kind of see what mom does. And I've seen the child a couple times since then, and I've asked, and he has kind of gotten used to the new normal of he doesn't ask about her. He doesn't know about Wednesdays anymore. He doesn't see her anymore. We did start him. I had contacted the therapist who actually did his CTAC, and she started seeing him weekly, still does. I think actually she just maybe discharged him last week. And she said that anytime that they would bring up mom, he would become immediately dysregulated, rip her computer cords, he would become aggressive, he would push stuff off the desk. And she said she did it probably about 3 different sessions. And then she had emailed me and she said that she doesn't feel comfortable essentially doing this to him. So she said that she wasn't going to address that anymore. And that she thinks that he had essentially, with his age and where he's at developmentally, I don't say that he's maxed out his therapy sessions for now, but he's doing well, as long as that topic doesn't get really brought up.
Was the individual that did the CTAC, was that Beth Abbott or someone else at the?
Aaron Abbott.
Aaron Abbott, okay, thank you for that. Other than the autism diagnosis, does this child have any other mental health or any other type of diagnoses related to his physical health?
No. He's doing really well.
And is he still participating in ABA therapy?
Right now, they're, it's kind of on the back burner, it's on pause. They don't have a therapist and they're trying to get it replaced. The family said that they'll look into other options if Blue Mind isn't able to facilitate that. I do know that there was a lot of kind of back and forth of the views of ABA therapy versus, essentially, in short, the family was struggling because with ABA therapy, their mindset is to ignore negative behaviors, whereas the school doesn't ignore them, and neither does the home. You know, they have timeouts or redirect, you know, and so it was very difficult for them to work all together because the child was getting different instructions from different people. So I think that the family might go a different route for therapy for him.
Since Ms. Devitt has stopped bringing up mom, has the child's behaviors stabilized?
Yes, and it wasn't like an ongoing, it was only like during that session.
Okay.
I asked, and his behaviors, I mean, from what they were months ago, he's, his communication is, I think, the biggest. You can talk to him now. He can communicate with you. So I think a lot of his behaviors were because nobody could understand them. So now that he has that piece, I think that it solved a lot of his behavior issues.
One of the things the court must consider is the fact that this is a relative placement and this is a maternal placement, relative placement.
Correct.
But has mom taken advantage of or benefited from this relative placement to the extent that we would typically see, like enjoying family holidays together or having additional access to the child to maintain that bond?
No, she has not.
And your court indicates that she hasn't reached out to the relatives either.
No.
And the relatives are willing to provide permanence through adoption?
Yes.
Is there anything that might prohibit them from adopting the child from your perspective?
No.
Does the child have his own room at the relative's home?
Yes, he does.
And as it relates to like age appropriate materials in the home, does he have any of those?
Yes.
And are they able to adequately supervise him?
Yes.
Has mom provided any financial support? Like when she was working, did she provide any financial support to the relatives or ask if they needed anything?
No.
I know that I just asked this, but the child also has fetal alcohol syndrome.
Yes.
Okay, sorry. No, that's okay. And are there any other specialized treatments in addition to what he's already gone through that would help him with that diagnosis?
Not to my knowledge. I think it's more of just better understanding certain behaviors.
Since he's been in care, has he gone to all of his regularly scheduled pediatrician appointments?
Yes, and more.
And has he gotten up to date on his like vaccines or anything like that?
Yes, he's current on all of his well child exams, all of his vaccines are current. He had significant dental issues. I think he had more crowns than, I think he had like 12 crowns. They're all now taken care of. At this point, he has no medical issues right now.
Is he still in speech therapy?
Through the school.
Okay.
They do the speech and occupational therapy at the school.
And he's still on track for the Young Fives program in the fall?
Yeah, he'll be doing, he actually no longer qualifies. He's not in the special education. He'll be in a general education classroom for Young Fives.
As far as like ethnic and cultural considerations, has the placement done anything to encourage, I guess, maintaining that connection to maybe even his dad's culture or ethnicity?
I don't know. I don't know the specifics of that. I know that the father did provide me with contact information for his relatives that was passed along to placement, and they had noted that, you know, when they were comfortable that they, you know, would reach out to the family.
Are there any updates as relates to mom that we did not touch on that you would like the court to be aware of?
Yeah.
Okay, thank you, Your Honor. As it relates to Ms. Caitlin Smith, I have no further questions for.
Very good. Mr. Brooks has rejoined us along with his client. Mr. Brooks, it sounds like we're about to head into testimony regarding your client. Any preliminary comments? Mr. Brooks, can you hear me? Okay, Mr. Zavala Garcia, were you able to successfully chat with your attorney as requested?
Yes, ma'am.
Very good. Well, I'm glad to hear that. All right, Mr. Brooks, we'll try to reach out to you again. It looks like you're muted on your end. Oh, there you are.
How about now?
Yes, thank you. Any preliminary comments?
No.
Very well. You may head into any questions you have regarding Mr. Zavala Garcia as well.
Thank you. Okay, Kristen, as relates to Dad, he has been incarcerated for the entirety of this case, is that correct?
Yes.
And were you able to have any one-on-one contact with him during this review period?
I mailed something, but I didn't receive anything back. I tried to, there's an app that I downloaded. I tried to deposit money in it, but the app, it didn't work on my end.
Is that the one that's referenced by litigation for?
Yeah, I think it's called like Getting Out or something.
Okay.
Getting Out visits. I was able to find him, find the prison, make an account, all that, deposit money, but I wasn't able to schedule a visit or it didn't work out.
Your report indicates that even after sending another letter to the relatives that he provided information on, you have not heard back from them?
Correct.
Dad's portion's a little harder to make sense. He hasn't been able to really comply with his case service plan. Is that accurate?
Yeah, there's not much that he can do.
As relates to following the incarcerated parent protocol, how are some ways that during this case you've complied with that policy?
So I have sent several documents to him for him to utilize while he was incarcerated. Parenting education handbook, substance abuse information, worksheets, workbooks. I've been in contact with the prison every reporting period. He did send me like a card allowing him to attend NA and AA while he was incarcerated, as well as a certificate of completion for, I believe, domestic violence. It could be anger management. And then I've reached out to his family, his parents, as well as sisters, by phone and by mail, informing them that they've been identified as, potential placements, and sent my contact information. In all my letters, I've sent a pre-addressed envelope with postage on it for him to return.
And have you also provided him updates of the child
Yes.
and any photos?
Yep. A couple pictures, his medical passport, a letter about his appointments, how things were going with school.
And were you ever able to set up visits between the child and Mr. Zavala Garcia? What was the factor there?
It was a recommendation from Mateo's initial therapist. She was through Washtenaw County's CMH. And the court had asked for a recommendation if we should start video visits or, phone calls. Obviously Mateo has never met his dad. And at that time, and for the duration of the case, it was never a recommendation made by the therapist to initiate that contact. They thought that it would be more confusing for Mateo to introduce him to somebody he has not met and unsure if he would ever meet. Mateo's language and communication has also played a big factor in a phone call.
I believe in the petition and then through the case, we've understood that Dad's earliest release date is 2026.
To my knowledge, yes.
And what would be the harm if this court were to maintain this case until he was released and could secure housing, employment, income for the child.
With Mateo's, with any child, sorry, with a child's age, specifically a child with autism and who needs that structure and routine and permanency. This case has already been going on for quite some time, in order for, his earliest release date, and then we have to essentially start fresh with introducing them, getting services in place. I'm not sure if Ruben plans to reside still in California, or he would come to Michigan. The child only knows, he knows his placement. He uses them interchangeably, but he knows them as mom and dad. At this point, all of his needs are met there. He doesn't know any different.
And this child does not know any of dad's relatives, correct?
Correct.
There is a support case out of Washtenaw County for this family, is that correct?
Yes.
Do you happen to recall when that was initiated or closed out? Okay. Do you recall prior to this case, dad was visiting the child at all?
No, I believe I spoke with Caitlin early on. I want to say that maybe he had met him once when he was very, very little, but I couldn't say for certain.
Okay. And as it relates to dad's review portion, did you receive any updated documents indicating any additional services that he's completed during this review period?
No, I have not.
And is there anything that you would like to say as relates to dad at this point in time? Your Honor, I have no further questions of Ms. Kristen Smith and would move to admit the court report.
Any objection, Mr. Brooks?
No,
No objection.
Thank you, they are received. Cross-examination, Mr. Brooks?
what is the department's position on allowing my client to have communication with his son?
At this time, we would not be in support of that.
All right. What is the department's position with respect to communicating with the people who are taking care of the boy?
I've provided the placement with his information, mailing address, as well as his family's contact information. And I've informed them that, they would be open to communicating with them. But that would be up to the maternal relatives. At this point in time, I don't know if they're open to that, but they do have all the contact information.
So in plain English, if he sent them a letter and they didn't respond, there's nothing much official that's going to be done about it, right?
Correct.
You've indicated that your understanding is that Mr. Zavala Garcia's earliest out date is 2026. Did I hear you correctly?
Yes, I believe that it was noted that he would possibly be eligible for parole in 2024, but that the release date was 2026.
All right. If he were to say that his earliest out date, he believes, is December of 2024, are you disagreeing with that?
No.
Okay. Would that information, assuming he was released in December of 2024, have any effect on your recommendation to terminate his parental rights?
No.
Why?
because the case was opened in
There's
November of
22.
Correct. And the child doesn't know him. He does not have any kind of relationship or bond with him. The child is doing exceptionally well. All of his needs are being met. And I don't think that waiting until December to potentially start services and start building that, I don't think that it would be fair or appropriate for a child of his age or with his, I don't want to say disabilities, but disabilities.
Okay. You agree with me that in his present circumstances, Mr. Zavala Garcia there isn't much he can do to improve his position with respect to the department. Is that right?
Correct. To my knowledge, he has engaged in services that are offered to him to better himself. But unfortunately, it's my job to make sure that the child is cared for and has permanency. And he can't provide that to his son right now
I
or in a
understand.
foreseeable future.
I understand. I have nothing further. Thank you, ma'am.
Ms. Heiss?
Are you aware of what charges, convictions Mr. Zavala Garcia is serving time for?
I can't think of the initial charge. I know though that he had escaped prison and that was
Okay.
added to.
Have you been able to refer Mr. Zavala Garcia for a psychological evaluation during this case?
No.
How about a psychiatric evaluation?
No.
How about any individual therapy?
No, not,
Have you sent him any parenting materials?
yes,
And did you include a self-addressed stamped envelope?
yes.
And did he return those exercises?
He did return some of them, yes. It wasn't essentially, we didn't need them back. It was more for him. It wasn't required that he send them back, but he did send some of them back, yes.
To your knowledge, does Mr. Zavala Garcia have any financial means to take care of this child?
Not to my knowledge, no.
Does he have any physical assets like a house or anything that could be used to benefit the child?
Not to my knowledge.
Mr. Zavala Garcia is incarcerated in California, is that correct?
Yes.
Was this child and his mom and Mr. Zavala Garcia ever a family in that state?
Not to my knowledge.
I think Mr. Zavala Garcia is someone who grew up generally around here, didn't he?
I'm not sure.
Okay. So this is I'm gonna skip topics for you with you. Regarding the calendar that this child MW, he has a real interest in his calendar, is that right?
Yes.
And at one point, we thought that he was really watching for mother's visits on that calendar and would really notice when his mom didn't come, is that right?
Yes.
Now, his mom hasn't visited in several months. He is still very interested in his calendar for every other reason, is that right?
Yes.
And he keeps track of family birthdays and that kind of stuff.
Correct.
Do you perceive that the placement family refers to themselves as Uncle, what's his first name? The placement's father?
Justin.
Thank you, Uncle Justin and Jill, as opposed to mom and dad?
Yeah, they do. They refer to themselves, but they won't ever correct him if he calls them otherwise.
In February of this year, we had a family team meeting. It seems like it was by Zoom or something. Do you recall that?
Yes,
And you had a family team meeting report in what the last court report, is that right?
I believe so.
Do you think that meeting and mother's, would you characterize mother's behavior as disruptive and you had to tell her to keep the camera still because she wouldn't sit still?
Yes,
And she was unhappy at that family team meeting, is that right?
Yes,
Would you say that that's a point in time that she maybe disengaged after that meeting?
yes, absolutely.
And it was attended by lots of people on the team, right?
Yes,
Okay. All right. So this child is placed with maternal uncle, is that right?
yes,
And in that maternal family, there are what would be to this child maternal grandparents, and there was a great grandmother, is that right?
yes,
And all those people see each other and live nearby each other?
yes,
So I think maternal great grandmother's passed away during the case, is that true?
I believe so, yes.
And then maternal grandmother is facing a diagnosis that she's treating for, right?
Yes.
But there are a lot of opportunities if mother, Caitlin, had a relationship with any of those people, she could access information, holidays, other family events, is that right?
Yes, when we were doing visits and it was not supervised by the agency anymore, but we had approved a support person for Caitlin. It was around the holidays and Caitlin was communicating with the family and they were communicating with her. I believe she had him on Thanksgiving, so they were coordinating, dinner and stuff like that. So that was available to her.
And you even went to the extent of, it seems like Caitlin doesn't have a driver's license, right?
Correct.
So you approved a transportation person and a supervisor for visits
Yes.
and really had to work to find time around this child's therapies in school to find time to get to the other community to visit with his mom, right?
Yes, they resided in, we're working in 3 different counties. Mother resides in Jackson, child in Washington and West Illinois, so.
Thank you, that concludes my questions.
Any redirect?
No, Your Honor.
Any recross, Mr. Brooks?
Yes, briefly. Ma'am, if you know, where does this boy fit on the autism spectrum?
I don't have that in front of me. I do know that it was submitted. His full evaluation was submitted as an exhibit to one of the court reports.
Does from you've met the boy, you've talked to the boy.
Correct.
Does he impress you as being impaired mentally?
He's visibly, I don't want to say we knew he was autistic before the evaluation, but it wasn't a surprise.
Thank you. And one last question, more out of idle curiosity than anything else. The mother's last name is Smith, father's last name is Zavala Garcia. Where does the name Wall come from?
That is the mother's maiden name.
Ah, I see. Thank you, that's all.
Thank you for your testimony. May I return to your seat? Any other witnesses, Ms. Thomas?
One moment, Your Honor.
You're welcome to.
No, Your Honor, I have nothing else for today.
Mr. Brooks?
If I can ask my client, sir, do you want to testify? Mr. Zavala Garcia, can you hear me?
Now you'll have to unmute on your end, Mr. Zavala Garcia. Gotcha. Okay, we can, I think we can hear you now.
All right.
Can you hear me?
Well, yeah, there's,
Well,
no.
wait a second. Can you hear me?
yes, sir. Can you hear me?
Yes. Now, you have to be sworn in before you say anything.
Okay.
All right, sir, please raise your right hand. Do Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
Thank you.
Uh,
Mr. Brooks?
What do you want the court to know?
I just wanted to let them know that, there's nothing much there wasn't much I can do. I've been incarcerated for quite a bit.
How long?
Emotionally, spiritually, I have no right. I know I have no right towards my son, Mateo. I never met him. I've never provided for him, or, my life since he was born, it's been quite. I've been in prison. So all I want to say is that, as if one day he ever wants to meet me, or if the family are willing to keep in contact with me, I would much appreciate that. I just want to let them know somehow in the future that I am here, and I anytime they want to reach out to me, and if they're okay with them letting know the child that, I'm the father. I know it's not the right time because he's a kid still, but there's gonna be a future. I just want to stay in communication, if it's possible, with the foster parents. I agree that I don't have the requirements to keep a kid, especially even when I get out. I first have to lift myself out first, and I just want to let the foster parents know, the people at the court, the judge know that I am here for him whenever the time comes, or if the foster parents want to contact me, or if they agree, that's okay with them. And finally, I just want to let them know that I am here for Mateo whenever the foster parents right now want to pretty much, open up to him, let them know in the future that I am the father.
I have
That's pretty much-
explained to you, I believe, have I not, that in the eventuality that the court decides to terminate your parental rights, you will have no recourse to the courts to enforce communication. You know that,
Correct.
right?
Correct.
I have nothing further, sir.
Questions? Ms. Thomas?
I have none, Your Honor. Thank you.
No questions.
All right, thank you for your testimony, sir.
Thank you.
All right, anyone else you'd like us to hear from, Mr. Brooks?
No, Your Honor.
Ms. Heiss? Any
Your Honor, I
witnesses?
have no witnesses. Thank you.
Comments in closing, Ms. Thomas?
Your Honor, may I start so that they can respond to my best interest recommendations? Sure. Thank you, Your Honor. I would like to indicate that I have been on the case since the beginning as his lawyer, guardian ad litem, and I have visited with him in person at his placement home. The placement home is a relative on the maternal side. It has a mother, father, and 2 daughters, and they are all bonded with this child. In the beginning of this 18-month case, the child was generally nonverbal, and he had very disorganized behavior. Now, when I have visited him most recently, he is able to speak many words, and he has, so I can read a page of a book and he can read a line because he knows what line is coming. First of all, that indicates that he's read that book an awful lot of times and that he enjoys it, and that he was using his words to finish the rest of the sentence. So the structure that is in place in this home is to Mateo's advantage. They are very well bonded with him, all 4 of the people in the household. At first, he was being babysat by his maternal grandmother, but she is taking care of her own medical issues, but there was extended family in the household. This child is 4 and he needs permanency and stability. He has started school and all the therapies that this family, his placement family, has provided for him, in addition to his medical and dental, his all the therapies that are working with him. They're on a pause right now, and it's probably a relief for a minute because they've been running so hard, including visits with his mother. The recommendations from the CTAC included a psychoeducation for anyone who is caring for this child around trauma because of his past trauma, complex trauma. It'll be interesting to watch as we go how much nature and how much nurture contributes to his developmental delays. In the right nutritious environment, will he catch up verbally with his fine motor skills, and his gross motor skills, I understand, are very well intact. There's a family pet, for example, that he's able to coexist with. But he did need his speech and language therapy. All of these things have been provided in the placement home. I think it's indicative that he still is fixated on that calendar, even after mom's dates are taken off. We all thought that he was watching for mom's visits, and he probably was, but that wasn't the only reason. He's very interested in the calendar. I believe he's too young to articulate to him. As the counselor said, that she stopped asking about his mom because he would dysregulate, and she didn't feel that it was appropriate to bring it up and to re-traumatize him. Aaron Abbott from Catholic Charities indicated that, so that we really don't know his wishes. We really don't say to him his narrative. He hasn't created his narrative about how he ended up being here and not there. So that'll be something that develops in time. There is a very strong likelihood that this family would be able to adopt, from my perspective of all that I've seen with them over 18 months. He doesn't have any siblings, any biological siblings with whom he has a bond. You know, the mother's failure to comply with treatment plans has been really apparent throughout the whole case. I have observed visits with her at Catholic Charities, so it's been probably at least 6 months where she has a lot of energy. This mom has a lot of energy, and I look to the professionals to say, what in the world am I seeing? And they say, oh, she's got ADHD. She just really is wound tight. But so it's interesting to me that she wouldn't accept the treatment that was recommended for her. That failure to comply with the treatment because she wanted a different treatment, I think really failed. She failed to serve the child in that manner because her parenting techniques were really fun for a child. I thought Mateo had a lot of, MW had a lot of fun in those visits, but it was crazy, kind of wild fun, and kind of loud, and kind of, he led the play and she followed. And so I think that if, judging by the lack of visits, lack of contact at all in this last review period, that we can know that the length of time it would take for Ms. Smith to rectify the conditions that brought the child into care is a longer period of time than is in the best interest of the child to wait. The advantage of the foster home over the mother's home, you'll remember that mother doesn't have an ownership interest in the home that she was staying in, and it was very cluttered, and someone had passed away, and there were, all their belongings were in there, and eventually she cleaned it up enough to for the caseworker to observe the house, but she still had no stability. When her job stopped in December, she still didn't report it to the agency, but that was one of the things she was confronted with in February, I think, when her behavior at a family team meeting was very agitated, and I think she disengaged at that point. But the advantages of the foster home, they live way out in the country, and there are these two cousins, older sister types, and they're very interested in this little guy, and they play with him. I observed a hat that one of the girls had made for Mateo, and it looked to me like a, you know, like a cigar box painted orange and black, turned upside down with a piece of elastic under it. And boy, was he really pleased with that picture. The foster family takes time to really celebrate his school. He had a book that he was looking at recently, and the foster mother knew the names of some of his friends, and knew the events that were going on in the pictures, so that there's continuity for him between school and home. And his therapies too at home. So I would ask you to consider that. I believe it's in the best interest of this child for the parental rights to be terminated and permanence be allowed him in an adoption. Thank you.
Thank you, Honor. In the interest of time, I'm just going to ask the court to consider the petition. I know that it's kind of lengthy there and going through each element of the case service plan for mom, but I do think it speaks for itself. The only thing I would also ask the court to consider is under statutory grounds at this point, I believe that we also have parent convincing evidence of abandonment as it relates to mother. She has failed to reach out for her child in more than the 3 months. And I believe the subsection on that is MCL 712A, 19B3, A1 or AI. And I know that we only need one ground for termination, but I do think that's really telling at this point in time that this kiddo, mom just disappeared from his life. And I don't know that she's really taking that into account. I want to say that I also appreciate Mr. Zavala Garcia's statement to the court. I think it's very honest, and unfortunately his decisions have put him in that situation, but it sounds like he recognizes that, and maybe one day the adoptive parents would permit that contact, but I think that his statement speaks for itself and is and supports our petition. Thank you.
Mr. Brooks?
Well, everybody here, including my client, knows the precarious position that he is in. However, I will point out that the virtually automatic precondition that he cannot be out of prison in at least 2 years does not apply here, and that he has the opportunity, he says a good opportunity, to be out in December. December is only about 8 months away, not 2 years away. So that's, as far as I'm concerned, that's off the table. The question is finally whether or not it is in the best interest that my client be given a chance. He knows he hasn't got much of a chance in this court. He would admit it himself if I asked him. But he is basically sincere in wanting a shot. And I ask that you consider it seriously. Thank you.
Thank you. The court finds all interested parties were given notice for purposes of today's review hearing, permanency planning hearing, and termination petition. I'm going to deviate, and I typically do the review findings first, but I'm going to tackle the termination findings and then because I think that will cover everything we need to cover for purposes of the review as well, and the permanency planning aspect of today's hearing. Termination of parental rights hearings are divided into 2 phases for purposes of the findings. The first is to determine whether there is clear and convincing evidence to support statutory grounds for termination of parental rights. The second is to determine if there's a preponderance of the evidence that it's in the child's best interest to terminate the parental rights of each parent in this case. The statutory grounds that the court has been asked to consider include, of course, the allegation of abandonment by the mother that was just raised a moment ago by Ms. Thomas. That is, as she correctly cited, 712A.19B3 The child's parent has deserted the child for 91 or more days and has not sought custody of the child during that period. I do agree that that is evident here. The court never actually suspended her parenting time, as we typically do when there's a pending termination petition, but rather left it up to the discretion of the therapist that was tasked with looking out for the interests of this child. We heard quite a bit today about his abilities and also his needs, and how important it is for him to have the structure and the routine and the support and the services that he's been experiencing in his foster home. And what an important piece that visitation played, and the risks associated with abandoning it, and the bond, of course, deteriorating between the parent and the child as a result of that. And that was definitely something that was available to the mother. She did participate in several different court hearings. She was part of this child's life for a few years before the interventions of the department brought him under the jurisdiction of the court and into foster care. And so it was a very conscious decision in this court's opinion that she decided to cease cooperation with the department back in February when she was confronted with some of the things that were necessary for her son at his age, with his needs. He needed stability, structure, he needed housing, employment, he needed a mother to engage in her services to avoid substances. And when she was confronted with some of the issues that she was still needing to face, instead of stepping up to the plate, she unfortunately walked away. She's had no contact with the department, no contact with her son since February, which is clearly more than 91 days, as today is June 18th. She's not here today, despite process services was reviewed by the court. She's not sought custody by contacting the department or the family members, her own relatives, that the court has information for. And so I do find clear and convincing evidence exists under that particular statutory ground. I also find that clear and convincing evidence exists under 3C. The parent was a respondent in a proceeding brought under this chapter. That's true. Both parents were, in fact. 182 or more days have elapsed since the issuance of the dispositional order. That's also true. And I do have, I believe, clear and convincing evidence that the conditions that led to the adjudication for both parents do continue to exist, with no reasonable likelihood that the conditions will be rectified within a reasonable time considering the child's age. I find further under subsection J, clear and convincing evidence that there is a reasonable likelihood based on the conduct or capacity of the child's parent that the child will be harmed if he or she is returned to the home of either parent. So I'm citing both of those sections before I do the factual findings on the basis of that, because I think that the same findings, the same facts support both of those aspects of the statute by clear and convincing evidence. Mr. Zavala Garcia appears to us from prison in California. He acknowledges that that is as a result of his choices. He was not, unfortunately, a part of his son's life before his incarceration or during. And he is eligible for release at best in December, but there is no guarantee of that. The earliest, or the maximum release date is in 2026. So I can appreciate Mr. Brooks's comment that the 2 years guarantee that he would be unavailable to his son is certainly not met in this case. But I will say that he has been incarcerated since the day of removal, which is 12/6 of 2022, and would remain incarcerated at least another 6 months, and that is the best case scenario. There is no guarantee that Mr. Zavala Garcia would be available to us at that time. We will have to go through that proceeding in order to request and be granted parole. It's highly likely that his parole conditions would include that he remain in California under the supervision of the court whom he has offended, and would be unavailable to his son in Michigan. It would be then a monumental task, frankly, for the department to work with California to see whether or not and how Mr. Zavala Garcia has remedied his capacity for decision-making that landed him where he is today, for example, as well as evaluating his mental health, his emotional health, and parenting skills to inventory those assets to determine whether or not they're appropriate for his son. Not only that, he has a son with accelerated needs. We've heard again about those diagnoses, including fetal alcohol syndrome and autism, and of course the trauma that he went through when he was in the sole care and custody of his mother. All of those things require intensive attention, services, and structure. And I do not see that there would be any reasonable time available to Mr. Zavala Garcia within the foreseeable future that he would be able to provide the proper care and custody of his child with those needs in considering his circumstances. Certainly, he cannot take care and custody of his child today, and I don't think that there's any reasonable time frame considering this child's age of 4. He's been in foster care again since 12/6 of 2022, and in a very traumatizing and frankly somewhat what's the word I'm looking for? I was gonna say debilitating, but it's been, before he was in foster care and receiving the maximized services that he needs to make the advances that he has made, he was in an environment that limited his development, to say the least, and rendered him, I think, really unable to make some of those advances that he needed to make developmentally, and have made it even more difficult for him to overcome some of the challenges that he has been faced with naturally. So, Mr. Zavala Garcia is not available to his son. He won't be in any reasonable time, considering the child's age and need for high structure, high parenting skills and abilities. And so I think that it's appropriate, and we do have clear and convincing evidence to terminate his parental rights under the 2 sections of the statute that I have cited. As it relates to Ms. Caitlin Smith, the mother of the child, she is also unavailable to him at this moment, and we have no evidence that she has been able to secure adequate clean housing, that she's working so that she could provide his services, that she has the transportation to take him to those services. She's been unable to demonstrate structure for him that would allow her to meet his needs, not only at home, but also in getting him to his services and activities and educational needs. We haven't seen any evidence. Well, there was some evidence that she was tackling her substance abuse issues at Victory Clinic, and even some evidence that she continues to go there. But certainly it didn't do her any good when we discovered through the vigilance of our caseworker that the evidence of the drug screens was being generated in a way that the Victory Clinic considers to be grossly inadequate and very much compromised. And then, of course, there is the fact that she refused to drug screen once this was discovered, that is very consistent with the court's findings that she has not demonstrated that she has been able to overcome the issue of substances or how those would affect her ability to function at this point in time. She did go through her psychological evaluation, which included, of course, a recommendation for substance abuse disorder treatment medications. She refused her medications for diagnoses, which is also very unfortunate. In order to help her overcome some of the things that were discussed by Ms. Heiss, some of those things are a characterization of the bond between the mother and the child as well, but also reflect her inability to understand, frankly, how important a structured parent-child relationship is for this child. That sort of wild, fun playtime with mom is great in bits and pieces, but this is a child who needs very high structure. We know from her inability to meet his needs before he was removed, both because of medically, emotionally and mentally, but also developmentally, that she did not have those skills and needed to develop those skills. And unfortunately, she did not demonstrate benefit from the nurturing parenting curriculum that she did finish during visitation and then abandoned that completely, unfortunately. So I do find clear and convincing evidence that Ms. Caitlin Smith's rights should be terminated under the statute, under those 3 sections. The best interest factors that are also met by a preponderance of the evidence. Unfortunately, Mr. Zavala Garcia was never able to form a parent-child bond with his child. That was true before this case and had to maintain that particular condition going through the jurisdiction of the court as well. And that was as a result of the child's need for stability, permanency, structure, and emotional. We had an expert along the way, not just our caseworker and our guardian ad litem, but a therapist for the child to advise us on that point, which is all the court can do in order to make sure that we're abiding by the needs of this child. And that expert did opine that meeting and developing a bond with Mr. Zavala Garcia would not be in his interest, given the challenges that he was already being presented as a result of his high needs, as well as the challenges around his bond with his mother and her involvement in his life. I've already alluded to the parent-child bond between this child and this mother, and that they're, although sweet at times and fun, certainly it was not characterized as you would typically expect of a child-parent bond, especially a child with such high needs. Of course, those were many of the reasons he was brought into care, because those needs are not being met, and that continued to be the observations of the caseworker during parenting time. So, although there is a bond there, we also heard about the child's adjustment to not having that involvement with mom, and how that's been able to bring a somewhat stabilizing factor to his life. And at some point when he's got a handle on some of the other challenges that he has, I'm sure that his therapist and his foster parents will broach the subject of his relationship with his parents and help him work through that as well. But that's certainly not enough for this court to stay the determination that it's in this child's best interest to terminate the parental rights of both parents so that he can be adopted. This is, of course, despite a relative placement that was explored very well on the record by Ms. Thomas, and all of the benefits that come with that, the extended contact, the family events, the informality and intimacy of a relative placement, none of which were available to Ms. Smith during this case because of her own choices, unfortunately. So despite a relative placement and the advantages that would provide, I do find that it's in the best interest of this child that the mother's rights be terminated, as well as the father's rights. Both of them, of course, will have the right to appellate review. We'll be sending copies of the orders terminating parental rights to Mr. Zabella Garcia in California, as well as to the last home address and email address that we have for mom, Ms. Caitlin Smith. The offer to forward each parent and attorney for purposes of appeals will also go with that. That request for the appeal and for the services of an attorney will have to be made within 21 days, which will be contained in the documentation that's sent to them, as well as the procedures for keeping their identifying information current with the Central Adoption Registry. The child will be committed to the Michigan Department of Health and Human Services for purposes of adoption or other similar placement. He will remain placed with the relatives pending the resolution of that. The order will reflect that there should be no further efforts towards reunification or to prevent removal. And we'll also issue the review order associated with today's hearing, which would give us 90 days until we need to look at the adoption process again post termination. Unless there's any questions, that will be all for purposes of the review and termination.
I have 2 points I'd like to raise, Your Honor, if I may.
You may.
One, toward the end of your decision, you referenced preponderance of the evidence. I am going to start with the assumption you are not referring that you were terminating based on a preponderance of the evidence. Is that correct?
Well, there's two parts, Mr. Brooks. The first is clear and convincing evidence, whether or not there's support under the statutory grounds. The best interest determination is one that's done by preponderance of the evidence. So preponderance was applied to the best interest factors, not to the statutory basis for termination.
Did you find by clear and convincing evidence that he should be terminated?
I did.
All right. The second issue, this is on behalf of my client, this is the one and only opportunity I will ever get to request that he be relieved of the obligation to pay child support in the future on this boy.
Your position on the motion, Ms. Thomas?
Yeah, I believe that resolves itself upon adoption. And I don't believe that Mr. Zabala Garcia is paying child support at this point in time. So I guess to take no position on that.
Yes.
Your Honor, this child has inflated needs, and the state is paying for those needs. And I don't know if the state has a claim against father for support until adoption or for the case leading up till now. But as far as paying to the child and his placement family, I don't think there's a purpose in leaving the child support open. Between now and the adoption should be 6 months, a year.
Very good. Mr. Brooks, I am, because of the elevated needs of the child, and frankly, I don't know whether or not there's a support order in place. But pending the adoption, I am going to leave the support obligation in place, if there is one, in order to support the department and the placement in trying to meet this child's heightened needs. But as I said, I don't even know if there is one in place right now. I don't have that file in front of me through Washington, so. And it will resolve itself upon the successful adoption of this child.
Thank you, Your Honor.